Deborah, I have another tough case that you don't know anything about.
So I should sit back down.
Mr. Weller's sleeping through most of this, but we're gonna wake him up here to do our hearing.
I wondered.
And it's got a lot of money involved and he's not real with it and he's late. And I'd ask if you would stay. I apologize.
Anything to make this.
It's another no lunch Monday. Why don't you go ahead and turn it back on for you now? I would have considered even maybe bumping this, but the complainant is here and he's been waiting for a long time. So this is file 23738 FY, People versus Timothy John Weller. Mr. Weller was charged with a felony computer crime. And as I mentioned, we're returning to the bad old days of multiple remands. This matter was bound over to the circuit court on a felony charge. A large amount of money was taken, $8,000, and it got remanded back to our court for a plea and sentencing. Well, I'm not sure I'm ready to do a plea and sentence, but I would be ready to do a plea. They're remanding these matters back for plea and sentence, but by the nature of the fact that they were a felony and came back as a misdemeanor, they're complicated. I don't know what happened. This case got bound over. There were several status conferences. It was going to be set for trial and it got remanded. And so the remand plea, Mr. Weller, would be to a misdemeanor charge of larceny over $200, but less than $1,000. The original charge was an allegation that you stole $8,000 from a Mr. Gregory White. That larceny charge is a just plain old grand larceny, punishable by up to 5 years imprisonment and a fine of up to $10,000. The computer part of it is a allegation that used a computer program, computer system, or computer network to steal more than 1,000 but less than 20,000. That's punishable by up to 7 years imprisonment and a fine of up to $5,000. You're also charged as a habitual felon as a fourth felony offense, making this punishable by up to life in prison. So the matter got bound over to circuit court. The can got kicked down the road a little ways, and then it got remanded back here for a plea to a misdemeanor charge of larceny more than $200, but less than $1,000. Mr. Weller, that's a misdemeanor. It's punishable by up to a year in jail and a fine of up to $1,000 or 3 times the amount of the money taken. In this case, it's alleged to be $8,000. So the prosecutor, and let me confirm this, Ms. Davis, has offered to dismiss the felonies and the supplemental for a plea to larceny over $200. And I understand you inherited this, but thank you for being here.
Quickly looking through the notes, it appears that yes, Prosecutor Marvin had made that offer larceny 200 to 1,000, and that the restitution was $8,000 joint and several between one.
She is set for sentencing later this month with Judge Pattison. All right, Mr. Weller. The allegation is that you're going to be ordered to pay $8,000 restitution joint and several with Heather Sproul, one of your co-defendants here. Do you understand?
Yes, sir.
Could you take your hand away from me? Are you going to plead to that misdemeanor charge of larceny over 200 but less than 1,000?
Yes, sir.
Mr. Bush, you confirm that's the plea?
Yes, it'll be more on an aiding and abetting factual basis, but we have previously discussed that. This is not a spur of the moment decision today.
All right. Mr. Weller, do you understand that if you do plead to that charge, you'll be giving up your right to have a trial in front of a judge or jury?
Yes, sir.
If you had a trial, you'd have the right to be represented by an attorney. Mr. Bush is here with you. You can also hire an attorney of your own choosing if you wished. If you had a trial, you'd have a right to have any of the witnesses for or against you subpoenaed to come to court, so they could be questioned under oath. You would have the right to take the witness stand yourself and testify on your own behalf, but you don't have to because you have a right not to testify. And if you did not wish to testify, the judge or jury could not hold your silence against you. And you have the right to be presumed innocent if and until the state was able to prove your guilt beyond a reasonable doubt. You understand?
Yes, sir.
Did you somehow induce the complainant here, Mr. White, to give you $8,000?
No, sir.
Well, tell me what happened.
I was solicited by Miss Heather Sproul to go open an account in my name, and what she did, she stole Mr. Gregory White's phone and transferred the money from his phone into my account. Somehow she got a hold of my account information and transferred the money.
Miss Sproul, let me see, because she's set for sentencing on a certain date. Let's see if we can line these up, save the complainant. Well, that can't be right. Set for sentencing on September 5th. So let's see how I look for September 5th at 10:30. It's next Tuesday. I can do it. All right, I'll accept your plea at 10:30. I'm not sure how we're gonna do this. Let's say it. Mr. Wilson?
Yes, Your Honor, when it please the court, I provided transportation for Mr. White because quite frankly, he has none. And I will not be able to do so during the month of September.
Well, I can, the other case is already set for September 5th. Mr. White, I can give you a bus pass to get here and back on September 5th. So I'll give you a round trip bus passes for that morning. But you're gonna need to be here for Miss Sproul anyway. So here's 2 round trip bus passes for you to get here on September 5th. Courtesy of generous people that watch this channel.
What time are?
I'm gonna set this for 11. The other one's at 10:30. Now, you called this morning, you were out of state or you had to be somewhere. How'd you get here today?
Cousin, my cousin brought me all the way back.
All right, how'd you get here to the courthouse?
My cousin drove up here, drove me here.
Where's he?
He took off. Yeah, I'm supposed to let him know how I'm supposed to get a hold of him because he has no phone now.
Hi, could you guys check and see if Mr. Weller drove here today? Yes, thanks. Bye. You've got a terrible driving record.
Yeah, they'll see me getting, you know, I have to cut you off again, but they'll see me getting out of a passenger seat of a maroon or burgundy colored Dodge.
All right.
And passenger side.
Now, in the
It was in this parking
report,
lot out
you're
here.
talking about driving. The other thing I need to confirm, I don't know whether that interview was recorded. According to the affidavit of probable cause, she gave you $3,600, which you took to Firekeepers and lost, except for $23. Plus you were driving all over the place.
I learned my lesson
I
from that.
made
Your
a
Honor.
traffic stop bearing a Michigan temporary plate, made contact with Timothy Weller in the driver's seat. I don't know what I'd do to keep you from driving. So there's a dispute about how much money you took. You don't have 2 nickels to rub together. I'm not very encouraged about this man getting his $8,000 back. But you agree that the restitution will be 8,000 joint and several with Miss
I'm willing,
Sproul?
like I said, I'm willing to make this right with him. I mean, I feel bad about it, and I'm willing to do whatever it takes to make it right.
And I do want to, I have not looked at this carefully, obviously, so in just going over the bank statement that I pulled up, there may be some withdrawal fees and that sort of thing. So
Okay,
I guess I would like to leave that restitution somewhat open. I mean, it's expected it's going to be around the $8,000, but there may be some fees. I want to get that cleared up so that the victim is made right. But I also have concerns about Mr. Weller's ability to be here himself on Tuesday. And if we have the victim coming back and the other co-defendant, I want to make sure that he is going to be here as well. So I guess I'll leave that to the court's discretion as far as that goes.
I'm willing to come back.
all right, yes, your bond's canceled.
Well, that's one way to ensure that he comes back. Cancel his bond, throw him in jail, and have the sheriffs escort him to his next court date.
They'll bring you back. And we'll deal with it. That's next Tuesday, which is 8 days. Stealing $8,000 from this guy certainly develops at least 8 days. Plus you keep driving a damn car.
No, I think he's been in jail for upwards of 45 days in this case.
Yeah, he bonded out. I'm not sure how. And I set the bond at the amount that was stolen. I think it got reduced when it was remanded. And I don't like these remands, and there's not much I can do about it, but they come in, they're always difficult to deal with. Yes, your bond's canceled. You're no longer presumed to be not guilty. I will see you next Tuesday at 11 o'clock.
Thank you, Your Honor.
What am I going to deal for?
Your bond's canceled.
Why is my bond?
Because
my
you
bond
just pled
still
guilty to helping somebody steal $8,000 from this man.
Yeah.
Plus you showed up late and slept through most of the earlier proceedings. I'm not sure what's going on with you, but I hope you're in a better state of mind when I see you next Tuesday morning. All right, you're free to go.
Thank you, Your Honor.
Why am I being arrested for? I don't understand. I'm almost done my pleas.
Oh, it's too late for that. We can discuss
Why am I
that
being
next
arrested
time.
for, man? I ain't
You're
doing anything wrong,
not
man.
arrested. You pled guilty to stealing $8,000
No, I
with,
pled guilty.
and then canceled your bond.
Man, it's crazy, man.
Yes, I think so.
Okay.
One of us is.
Why am
All
I
right,
being
I'll see you
arrested
next
for, man?
Tuesday.
Now let's step back and break down what we just watched, because this case is a perfect example of how courtroom decisions aren't just about guilt or innocence, but about credibility, responsibility, and protecting the victim from further harm. At the center of this case is an $8,000 theft, originally charged as a felony computer crime, which carries serious prison exposure, especially when you factor in the habitual offender enhancement. That alone could have put the defendant at risk of years or even life behind bars, but through negotiations at the circuit court level, this case was remanded back down and reduced to a misdemeanor larceny charge. And here's where things get interesting, because even though the charge was reduced, the restitution never changed. $8,000 is still $8,000. No matter how the label shifts, Judge Middleton makes it very clear throughout this hearing that while plea deals are a part of the system, they don't erase responsibility. And that's especially true when the defendant's own statements start to unravel. The explanation offered that the money was transferred into his account without his knowledge, that he believed it was inherited money, and that he somehow didn't question receiving thousands of dollars is exactly the kind of story judges hear all the time. And just as often, they don't believe it. What really stands out here is how the court responds to behavior, not just charges, showing up late, sleeping during proceedings, admitting to gambling away stolen funds, continuing to drive despite a terrible driving record. All of that matters. That courts don't operate in a vacuum. They assess whether someone is taking the process seriously. And in this case, the answer was clearly no. The decision to cancel bond wasn't about punishment. It was about accountability and ensuring the defendant actually shows up for sentencing. When someone pleads guilty, admits involvement in a scheme, and demonstrates ongoing disregard for court orders, the presumption of innocence disappears. Judge Middleton spells that out plainly. This isn't about confusion, it's about consequences. And let's talk about the victim for a moment. The person who lost $8,000 is the one struggling with transportation, scheduling, and repeated court appearances. Meanwhile, the court steps in to make sure the victim can physically be present, even providing bus passes so the case can move forward. That's a powerful reminder of who the justice system is supposed to protect. So here's the big question for you watching at home. Do you think reducing charges like this actually serves justice, or does it risk minimizing the real harm done to victims? And if you were in the judge's position, would you have handled bond and sentencing the same way? Cases like this show that courtroom outcomes aren't just about technicalities. They're about patterns of behavior, credibility, and whether someone is willing to make things right without excuses. And when those pieces don't line up, judges have tools to step in and stop the cycle before it continues. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. And these are the cases that remind us why accountability matters and why the details always tell the real story.